Mr. Brown, you are charged with reckless driving. You're facing up to 30 days in jail and or a $200 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay, good morning.
Good morning. On May 14th, 2026, in Harris County, Texas, officer observed a group of vehicles leave the tunnels near 610 and Woodway Drive. The vehicles began accelerating at a high rate of speed, reaching 140 miles in a 65-mile-per-hour zone. Officer then observed two motor vehicles change lanes and go back again without signaling, nearly striking a semi-trailer tanker. The traffic stop was conducted and the driver was identified by his Texas driver's license. And his license is not currently eligible.
Mr. Brown, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. I'm ordering you not to drive. I don't give a rat's behind what you have to do in this life. You do not have a Texas driver license. You do not have liability insurance in your name. You will be signing a promise with me. This is an affidavit that you're going to swear to me today that you're not going to drive. You drive, I can have a contempt hearing, and every time you drive, punishable by 180 days in jail and a $500 fine. Do you understand? You are also on bond for a felony case. It's very possible the fact that you pick this up, they may revoke the bond upstairs in that felony court. It would probably be a good idea to get a lawyer quick. Do you mind filing those conditions, please?
Yes, Your Honor.
And no weapons.
Yes, Your Honor.
I'm going to have you come up here, swear to us that you're not going to drive. You will go sign a reset. After that, we were going to have you take a seat in the jury box. We'll get your bond conditions. Once you sign them, at that point, you'll be free to go. Mr. Gans, how many DWIs does he have in total?
One US conviction on a base, and then probation, Brazos County, 2022. It's open now because it's in revocation.
Then that's why I did what I did.
No, I understand. I understand.
You know,
I wasn't here, and I just actually got the US judgment shared today. I didn't even, I mean, I knew about it, but I didn't know what was the result. You know, I'd never seen a judgment from the feds.
we don't do stuff here just to be harmful or obtuse just for, that's not the way we do things. But you got to understand, Mr. Martinez, is that, tell me, why do we have jails? Yes. Why else?
People get better.
Yes, that's absolutely right. It's also for people who don't learn their lesson, who come back over and over and over and have one overriding thing that controls their life forever. With you, there's one thing that has been controlling your life for the last 15 plus years. What is that thing? Right. And I don't know what the hell it is that cannot get into you to understand and see the fact that on a daily basis in Harris County, every day, someone dies from an alcohol-related collision, calamity, accident, mistake, choice, whatever you want to call it. And we need to do the TRAS now.
Yes, sir.
Because I would really like to know what they're going to do with Mr. Martinez in light of. So tell me, because I didn't get, how many actual DWIs does Mr. Martinez have?
So he has a deferred here well, not here, in Brazos County.
Is he on deferred now?
No, it was in 2022.
Okay,
From my understanding, it is complete.
okay.
And then he was on probation in his federal case while he was in the military, from what I can see.
Is that one still open now?
That was a probation. Let me see the date of conviction.
So it's just those two.
Just those two, I mean, still two, it's a lot, but
Sure.
2019 is whenever you pled guilty and entered probation, you did a 1 year probation. So it should be-
So please let the system and them know that he has a federal one, so because they may not catch it, so that when they do the TRAS, they see that he has two actual DWIs, because if they run some kind of, like TCIC or NCIC, they might not see it because it's a federal case. So, the reason we have jails and prisons are for people who don't get it. And hopefully you will not make a choice, because it's not a mistake, it's a choice where you go out and kill someone. I was watching on the news yesterday of a guy that goes to a bar, has about 12 beers at a bar, then gets into his car, goes to a gentleman's club, and proceeds to take 5 immediate shots of alcohol. He's so inebriated by the time he gets up to go to his car, he falls down. And what do? Give him a freaking another shot. Gets into a car, driving the wrong way down the freeway, kills 2 girls. One of them 19 days into being married. 19 days into being married. The other one was a recently made fiance, killed. Now he will be doing 80 years in prison because they sentenced him to 40 years on one. They sentenced him to another 40 years and they ran it consecutive. You never know what's going to happen when you get out there. You don't mean to do it. You never wanted to do it, but it happens. You're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is 1 year in Harris County Jail to be probated for 2 years. This will now reflect as a second. Actually, is it a second conviction?
It is, but actually, no, this would be his third conviction. We're working this out in lieu of refiling it as a felony offense.
No kidding.
Yes. Which is why it's a maximum probation. It's 2 years with the 5 days.
So it's actually that many. So they need to know that. There's a very big possibility. One of the things I'm ordering you to do now, Mr. Martinez, is to undergo a TRAS, which is an evaluation to see what conditions you need. It's very well possible that they order you to undergo inpatient treatment. If they order that, you're going to do it as part of the probation. Do you understand?
I understand.
You will do 5 days in confinement starting today. No drugs, alcohol. You must maintain a guardian interlock, a DWI, repeat offender education class, 1 victim impact panel, no breath test refusal. If you are pulled over driving and an officer asks you to submit a breath test for the next 2 years, you must do it. 50 hours of community service. If you fail to live up to this probation, I will issue a warrant for your arrest. We will have a hearing to determine if you violated this agreement. If you do, you were looking at 1 year in the jail. You understand?
Okay.
You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront, cross-examine your accusers, right to be arraigned, charged, read in open court. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. This is final today, it's final forever. From now on, if you do ever pick up another DWI, you will be facing up to 10 years in prison. Is that what it's going to take to get you to finally understand? I don't know. Many people here say, no, I'm never going to do it again. I'm done. I'm no more alcohol, this, that. You're going to forget about this because time heals all wounds. In 10 years, you're going to forget about all this, but the law never forgets. And I'm telling you, the next time you're pulled over, even if you have the faintest smell of alcohol, when someone runs you and they see DWI, 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 what the hell do you think they're going to do? You already know. Right. If it walks like a duck and it talks like a duck, how do you plead to the offense?
Guilty, Your Honor.
I'm going to find you guilty. I'll follow the agreement, sentence you to it. Good luck to you, son.
Suspended his license. Oh,
2 years.
2 years.
Do not drive. I don't want you anywhere near a car. Baby steps. We have to trust you before you even go near a car. I have to see substantial compliance, and then I'll consider, but I mean, considerable that you're doing well, and then we'll go from there. But at this point in time, with all this baggage, I don't want to put my name on a license and you go out there and kill someone. I don't need that kind of drama. You understand?
I understand.
All right. Good luck, sir. Thank you, Mr. Gates. Thank you.
There's still, there's something with the Brazos. I understand the prohibition with 2022, but there's something about fees. I don't know. I haven't gone to Brazos County.
Do you owe money in Brazos?
I didn't think so. Last time when I went over there to,
Do you guys see a KPX? What gives you the feeling?
Well, because they sent him a letter saying to appear in court, and then so he wanted me to represent him there,
That's a
told you
big
about
call
that.
because that's a far drive.
and so
I don't know.
Right.
So you only have 5 solid days to do. After that, you're gonna get out. It just, you need to, because if they issue a warrant and you're here in custody, they'll put a hold on you here. And then, I don't know if Brazos will come for him or not. I don't know, but
he has a reset date, so I think he'll be fine.
but just make sure, don't drive. I'm telling you now, the worst possible thing you can do in this life, Mr. Martinez, is drive. I've ordered you not to drive. We're going to have you sign an affidavit promising us you're not going to drive. I don't care how important it is for you to do this or do that. Find another way. Please do not drive. Do you understand?
I understand.
Okay. All right. All right. Good luck.
Thank you.
Thank you, Mr. All right. With that,
Thanks,
it's
sir.
are you representing both? Or are you representing just
No,
Mr. Lane?
no, Your Honor, just Mr. Lane.
Okay, as you can, guys, gentlemen, both of you are charged with public lewdness. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you. Who's Mr. Lane? Just so you know, your lawyer's here with you, but he's on Zoom. Okay? All right, please.
On May 13th, 2026, in Harris County, Texas, officer was conducting patrol in a shopping center, which included a daycare, and observed a vehicle with the rear left passenger door open and defendant Nunez standing naked with his buttocks exposed to the public. Defendant Nunez stated he met defendant Lane on a dating app and they agreed to have a sexual relationship. Defendant Nunez picked up defendant Lane and parked at this location behind the daycare where he was receiving oral sex from defendant Lane,
Who saw?
the officer.
Okay, gentlemen, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you guys are ordered to keep it indoors, not outside, and not to go back to this location. Do you gentlemen understand? If you violate these conditions, I will order your arrest. You will both be put in custody. No more PR bonds. This is not a revolving door. Each of you understand. We will have bond conditions created for you to sign. Once you sign them, at that point, you'll be free to go. Mr. Lane, first, we'll have you go. Once you sign the reset, we'll have you take a seat in the jury box. Once you sign the bond conditions, at that point, you'll be free to go. Because you have a lawyer, I will waive your appearance. You do not have to waste your time coming to court. So stay in touch with Mr. Davila, and he'll tell you if and when you have to come back to court. Stay in touch with him. Do not pick up any new cases. Do you understand? Please.
Judge, for council house, July 21st through the 23rd. Hang on one second.
23rd, please.
Okay.
Okay.
Have Nunez up first. Nunez, right this way.
No, hold on.
Oh.
Let me see. Mr. Nunez, tell me about, do you have the ability to hire a lawyer? How do you support yourself? Stop. Don't. Please. How do you support yourself? You need a lawyer. You're facing a lot of time in jail. Not only that, this can have a disastrous consequence on your record. So you need a lawyer. So all we're talking about now is, can you afford a lawyer?
No, sir.
How do you support yourself? Do you work?
Yes, sir.
What do you do for a living?
For construed.
Okay, I can have you fill out an application. She will give you an application, fill it out. I'll take a look to see whether you qualify. I'm gonna have you take a seat in the jury box. Do not leave until you sign the bond conditions, all right? Please. Hey, are you ready? Hi,
Good morning,
what's up?
Top Rocket.
Okay,
He is going to miss his testing this morning.
why?
He is not there tomorrow.
What?
He's on the phone to go to funeral.
No, no.
Yesterday.
I'm gonna issue a warrant. It's just too much. It's too much. There's always something. You got to get approval first. You're on bond. I've ordered you to undergo testing Monday and Thursday. You've had 4 bond violations. That's it. If he doesn't show up at that point, they'll file a BVR tomorrow and then that's it. I mean, actually, no, he's supposed to show it today. If he doesn't show it today, at that point, I'll revoke the bond. So I'll leave it till the end of docket. Okay,
We can wait to see if it's.
it's just too much. I
You
mean,
need to issue it by tomorrow, as far as I know. It's
well, no, I mean, he's supposed to come today. I guess I'll do it until like 3 o'clock.
So he has until 4:30. I can remove the supervisor, you can submit it earlier. He's really wants something easier until 4:30.
Sure, that's all right. Yeah, but nevertheless, he's supposed to show anyways. He's on docket to show here in court, right? So I know, I get it. We'll deal with it when we do it. Okay, thanks. Hi, good morning. Please.
With Ms. Rose Ortega, first name Ella, she is in the jury box, but she comes as a family member.
I was just about to email you.
Okay,
She picked up a felony.
yes, I've already got, there's a court my attorney, I've been trying to contact him to let him know that she had retained him. I've been in contact with him to do the motion.
I can't let her go though. You know that, right?
I spoke to her this morning, and we can do, the walkthrough if I can pick her up and bring her back, or do you want to address this one first, or how would I say it?
Yeah, I mean, I'm gonna, let's get ready. Cruz Ortega, come up.
And to proceed, I haven't been able to speak to the attorney to let him know that I'm somebody's out, so. I've contacted him, emailed him.
I get it. So the thing is this, is that you have an open felony warrant for continuous family violence. I cannot let you go. If I were to let you go now, I'll get in trouble. Deputies get in trouble. It would be a huge mess. I can't do that. So the only way something can happen is if you go get a deputy from the 209 and they come down to get her and escort her upstairs. That's something. But I'm going to tell you now that she's on bond for a case here. If she's picked up a new case, especially with the same complaining witness, we will have issues. But I'm not going to do anything until that court, finds probable cause. I'm not going to revoke the bond here until she's formally been found with, probable cause. So
Okay, so let me.
the only thing I'd like to know is it the same complaining witness?
Yes, Your Honor.
How bad are we talking?
So the allegation is that
Shh.
the defendant struck complainant twice in the mouth area with a closed fist, causing him pain and to begin bleeding from the mouth. The complainant also advised that his car was damaged and he believed the defendant caused the damage.
Okay. All right. So
The complainant has contacted the DA's office. And pursued charges, but we haven't had the chance to.
sure. Yeah, they're gonna have to do more work on that for sure if there's gonna be a criminal issue. So we're gonna take you into custody now. I'll wait for you. I mean, you have until the end of docket. If something happens, great. If not, then we'll just take her down and now she might not see a master till tomorrow or Sunday, depending on, when they get to it. So, okay, just let me know. Yeah. Okay, sure. Hi, Dan. You ready?
Good morning, Jared.
Hi, good morning.
I'm here with Mr. Josue here.
And we received this PPI contract yesterday. So we just reviewed and signed it together. He needs to get it notarized, pay the DA fee. He already has the files.
Great.
So we feel like a week or 2 weeks to.
Not, let me see how old it is first. So it's 200 days old. We'll give you a week.
Okay.
Okay, if it's not done in a week, let them know it gets rolled day for day. Okay?
Got it. We'll get-
Okay, thanks, Dave. Take care. Hi, you ready?
This is for a non-disclosure. So we.
What's the last name?
Last name is Eugene.
Eugene?
D-E. J-E-A-N, Eugene.
I see it. Okay,
We're opposed, Judge. Reason being, if I'm reading the code correctly, and I'm not great at reading, but what I'm looking at.
I'm with you.
Is 411 .0728 C2. So there's an exception, of course, for these types of charges, prostitution charges. If they are done essentially as a victim of human trafficking, which I'm not going to dispute that. The problem we have is subsection C2 prohibits a non-disclosure on these types of charges if the person picks up another offense. It lists a number of offenses, which includes theft offenses. She was put on a deferred adjudication in Chambers County for a theft in 2020. So because of that charge, I don't believe the court is able to grant her non-disclosure on this charge.
Do you know the disposition on that?
Last I saw it was just deferred. I didn't see there was any kind of final resolution if it was finished.
Felony or misdemeanor?
It was a misdemeanor.
Misdemeanor? Tell me your response,
So,
please.
from my understanding of the statute, those crimes, prostitution, theft, possession, they're all grouped together as far as these that victims of human trafficking would have to be under those circumstances. The charges she has in Jefferson was a misdemeanor C, and you were also going to find.
Class, wait. Is it a class C or class B?
It was a class B.
For Jefferson. She's mentioning Chambers County.
Oh, so she has multiple cases.
So we're filing a non-disclosure for that. I didn't file them all together since there's.
How many cases has she picked up since then?
So since this conviction in 2014, she has had in Beaumont a possession of marijuana charge she was convicted of in 2017 was a misdemeanor amount. There was that in Chambers County. I think that's all I see. There were some other, like they called in charges, but they.
So how do you get by the fact that she's picked up at least 3 different cases, right?
Well, the distance in time and also that it was.
Does the code say the distance in time makes her eligible?
No, so the fact that they gave her the third in Chambers, they didn't qualify her for the, so when we filed a non-disclosure for that one, it would not be under that specific statute. I filed it under the 411.372 in Harris County, was specifically because the prostitution charge is the one that's been causing the most problems. It's been coming up and kind of causing like the extreme embarrassment for her.
I didn't hear, it's been causing what?
Often difficulty for her to find a job.
Not the thefts?
No.
Really?
The theft thing with Jefferson was I think a ticket only, and then the deferred now. They haven't disputed that she really didn't have it here, so we just wanted to try to attempt to get the one that was causing the most issues for her.
Is there any evidence that she was trafficked?
I mean, according to her attorney, I'm just taking her word for it. I mean, it's prostitution charge.
You still have you don't have the OR though, do you?
I'm not sure. So it looked like it was contacted on a website, backpage.com. It's HPD, so I'm seeing if I can pull the pull the office report, it's like it was an undercover officer who was essentially set up, responded to her escort ad on the website. So I've got an office report, you know, into whether or not she did it. I mean, the only reason I was opposed, Judge, is because of that she did a deferred on. From my understanding of the code, the court doesn't have discretion if you grant her a non-disclosure for this prostitution charge because she picked up the theft charge and did a deferred on after she was convicted.
Tell me, how do you get by that? How do I?
So that was not my understanding of the statute. I thought because of the charge, since they have it listed, that it would be one of those that would.
Right, but it is, right? But you have to go beyond that because she picked up multiple offenses since there, right? So you get through one prong, but there's another prong that may be barring you from granting it. If you show me that I can, go back to the statute, look at the statute. If you show me that I can, then I'm amenable to it. You know, I always like to help people who want to better themselves. I don't have a problem with it if you show me that I can, because he's saying I can't at all. Even, you know, typically there's always this in the interest of justice, right? Show me where I can, and then I'll most probably do it. Because, you know, if someone wants to better themselves, who am I to step in the way? And I would rather her work and find something legitimate than to, you know, continue to, because she is barring her from getting something, then we end up back in the same vicious cycle over and over and over. So I want to show me that I can, and I will. Okay, so step down, look at the statute, show me, and then if I can, I will.
Thank you, Judge.
Yes, ma'am. I'm looking at it now, but I just, you know. Is she with you? Michael, just give me a second. Really? Is this a good idea, Ms. Duplachain? You know, the thing is that you can lie to me, you can lie to your lawyer, you can lie to your mama, you can lie to your puppy, but you can't lie to yourself. Only you know if you can make this or not. And the problem is ours is just kibbles and bits compared to what you got upstairs. Is that a third degree upstairs?
I believe it is. Yes.
I mean, you're looking at serious time in prison if you pick up yet another case. 1, 2, 3, 4, and you constantly, you have never appeared, not even once. Is this a good idea?
Yes, Your Honor. I believe.
Why?
Because I've spoken with her family and she has familial support now. And I believe that she's on the right track. She does see, as I've been meeting with her, she does seem more clear-minded than ever before. And she knows that if she screws up, the felony says what's going to bite her.
Everyone's on the right track when they're in jail. What defines you, Ms. Duplachain, is what you're going to do when you get out. Will you continue to be with the wrong people, or are you the wrong people that's dragging everybody else down? All I know is now I've had to make all your bonds 15,005 because you continue to pick up cases and you continue to fail to appear. Did we do a TRS?
Yes, sir, the felony court did, and it recommended the young adult. This one, I think, the version.
Is that what they ordered upstairs? Okay, let's do it. You know, I'm going to tell you now, if you come back because you failed to do anything, it's really not going to go well. Which one are we going on?
That case, Your Honor.
You're looking at an entire year in jail with us if you violate this agreement. Do you understand, Ms. Duplachain? Life is hard enough as it is being a young Black woman in society today. And the fact that all these thefts, what do you think is going to happen in 20 years? Think life gets easier? It gets harder. You are young. You have yourself now. Life doesn't get better the older you get. You get bigger, fatter, you lose hair, you're not as good at remembering things. Your eye go back, just everything sucks the older you get. And the more crap you have on your record, you're charged with a terroristic threat, a Class A theft, and a failure to ID as a fugitive from justice. The agreement you have worked out is a 1-year deferred on the theft case. I'm assuming the other two will be dismissed.
Yeah, it should be in the top of the paperwork as well. It's written in there, other than on the actual.
For you to complete this successfully, you must complete an anti-theft course and 8 hours of community service and complete the young adult caseload. Is there any restitution that's due in this case?
No, Your Honor, it was a theft from a Lululemon, and I believe the merchandise was returned.
Great. You are giving up the right to a trial, the right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charged with in court. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You give up damn near every right known to man entering into this agreement. If you complete it successfully, there's no conviction on your record. But if you violate this thing, I'm going to issue a warrant of arrest. I will remember you because I'm not going to forget this. If I have to get you back, the bond will be double, if not triple. We will have a hearing and you were looking at a year in jail. Do you understand? Somehow we have to get your attention, Ms. Luplachain, whether it's doing these classes or sitting in the county for a year. I hope it's not the latter, but you hold the keys to this cell and no one else. Are there any co-defendants?
I do not believe, so, Your Honor, I'm checking right now.
Yeah, I'm check twice. It's upstairs, it's an organized retail theft, so.
On our theft, it does not reflect Your Honor.
No contact with any of the locations with the theft, no weapons, no drugs, no alcohol, no weapons, no contact with any of the co-defendants in these cases. Did you graduate from high school? Great. What else do you want to do with the rest of your life, Ms. Chain? If you had any wish in this life to be whoever you could be, what would you want to be?
Entrepreneur.
Doing what?
Nails.
She wants to start a nail business.
It's not hard. Start working at a nail salon, figure out how to do it. Problem is that you got to be honest in this business. If you're going to run your own business, you got to be honest. Otherwise, you're not going to get the people to come see you. How do you plead this offense? Guilty or not guilty? I'm not going to find you guilty. I'll withhold that for a year. Waive all your fees. I'm going to waive all your fees. It's not about the money. It's about you learning something so you don't come back. All right, good luck, Mr. Chain.
Morning, Your Honor.
Hey.
How are you?
Hi, what's up?
I'm here just on that motion to restore property from last week. We were waiting on the offense report, reports.
Were you able to,
Yes, we do have off.
I get it, but do you verify because the serial numbers weren't matching the last time we were here? That's why we,
Oh, okay, yeah, let me check on that. If I need
yeah,
to
that's the problem is the serial numbers didn't match and
I
that's
can-
why.
I can revise that.
Okay. Alan,
Yes, good morning, Your Honor. Regarding Ms. Ferguson, she was asking if she could be rolled day for day to try to complete the PTI.
no, it's 380 days, dude. We're way beyond that. Come up, ma'am. What was the last name again, Alan, please?
Ferguson?
That's right. You know, the look of disappointment on your.
Let me read you this because it's genuinely infuriating. A woman named Miss Ferguson was given a PTI, pre-trial intervention, offer that required her to complete 1 class and 4 hours of community service. That's it. 1 class, 4 hours, and her case would be dismissed. No conviction, no criminal record. Her case is now 385 days old. The judge sets cases for trial at 180 days. She's had more than twice that long to do something that would take a normal person a single weekend. And she did nothing. Her excuse: her car got towed. The judge's response: it's nearly 400 days. I'm not going to accept any more excuses. At some point, we have to let people put their big boy, big girl pants on. Now her options are time served, a 3-month deferred adjudication, or trial, where she faces up to a year in jail. This is what happens when you take a second chance and flush it down the toilet.
Lawyer's face. The fact that you literally had 1 class and 4 hours of community service for dismissal in this case, and yet time and again you failed to do anything. Your case is 385 days old. We set cases for trial at 180 days. You need to go out there and figure out now whether you want to accept. Do you have another plea bargain agreement on this case, Sean?
Sorry, Bill.
Please, this is Miss Ferguson.
Yes, sir.
Your Honor, if I may, I can tell you that Ms. Ferguson just said to me that if she can't do the PTI, she wants to go to trial.
I'm happy to do it, but here's what we're going to do. If you want to go to trial, I'm happy to do it, but I will not accept any more plea bargain agreements after today. Today is your plea bargain deadline, meaning that you can either accept what they have to offer. If you don't, and which you don't have to, it's your prerogative. At that point, we set your case for trial. You will go to trial kicking or screaming. You are facing a year in jail. I don't like to play games. I have enough drama in my life. I'm not going to drag everyone down here, 35 people who hate to come to downtown anyways, and have them prepare, have your lawyer prepare for you to just plead guilty on the day of trial. It's not going to happen. If we said it, you will go to trial. Do you understand? I don't want you to make a decision now. I can have you step out, talk to your lawyer. You guys make the decision. What's the alternate offer that you've made?
Judge, there's PTI, there's time served.
No. PTI is off the table. It's not going to happen.
There's also time served or 3-month deferred.
Okay, those are the offers that they've given you. You need to discuss it with your lawyer now. Time served, a 3-month deferred, or we can set this case for trial. Please step out, talk to your lawyer, and just when you're ready, come back.
Your Honor, I'm sorry, just two last things. First, she did say that her car got towed when she left court last week, and that's why she wasn't able to pay for the class. She asked me to communicate that.
Alan.
Yes, sir.
It's nearly 400 days. I'm not going to accept any more excuses. You had day after day after day. There are that's it. At some point, we have to let people put their big girl pants on. That's it.
Yes, sir. Yes, sir.
So
the last thing, Your Honor.
Go ahead.
I'm in the middle of the ocean, so I'm not able to enter a plea if she wants to take the deferred. So if she does want to do the deferred.
Can you just explain to her the plea paperwork real quick, if that's what she wants to do?
Yes, I can. Absolutely.
Please.
I'll step in for the meetings.
I have someone ready to step in. I have, that'll help explain the plea paperwork if you'd like, Alan.
I would. Thank you.
Negotiate it for him. I'll explain the
Sure.
paperwork and take the plea with her.
So if you just step out, explain to her, see what she wants to do, and then we can have someone else take the plea for you.
Yes, Your Honor. Thank you very much.
Thanks, buddy.
Okay, bye-bye.
Bye. Are you ready? Come on. Okay. Is this person here?
Yes, he is.
Okay, do you mind bringing him up?
Oh, sure. Oh, we might have just stepped out a second ago.
Sure. And then,
There he is.
all right, come around this way, please. So do we need to do bond conditions or?
It appears that way, yes.
Yeah, okay. Did you just get out of jail or something?
No, we had an issue last week where we were out of town, and so we moved the date.
Got it. All right. So, Mr. Oliver, you're charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon, On the gun case, you're facing up to a year in jail and or a $4,000 fine. On the DWI, up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
On May 6th in Harris County, officer observed a vehicle with expired registration on Old Spanish Trail. The traffic stop was conducted on the vehicle. Defendant was the sole occupant driver. Officer observed strong odor of alcoholic beverage from the defendant's breath, slurred speech, and watery eyes. Defendant admitted to drinking prior to driving. Officer observed a cup half full of Hennessy on the passenger side floor, as well as a firearm in the center console, unholstered. SFSTs were conducted, 6 out of 6 HGN, 2 out of 8 walking turn, and 2 out of 4 one night stand. DIC was read. Defendant refused to provide sample. Blood search warrant was executed. Blood was drawn.
Mr. Oliver, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you are ordered not to drive any vehicle that's not equipped with an ignition interlock on it.
Your Honor, may I speak on that for a moment, please?
Sure.
Mr. Oliver works as a commercial driver. He works on. Yes.
You tell me he has a CDL?
Yes.
There's an open cup of alleged Hennessy in the car.
Yes, Your Honor.
Stop.
No, not you. Okay. Yes, Your Honor. He was in the car with his girlfriend. We would argue that the cup belonged to his girlfriend. We'd say that it belonged to his girlfriend. She also claimed to have the scene. So there's that, sir. Also, he works inside the plant. He drives vacuum trucks for the plant on private plant property. He has drug tests that are done regularly on him to make sure that he's clean. If the court would consider giving him a portable device rather than an ignition interlock, which does not have a permanent car, but we'd be willing to submit to as much portable testing as the court would require.
I'm going to order that any vehicle that he drives in a personal capacity must have a interlock on it. You will also get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. I don't care where you're going. I don't care what time it is. If you skip a test, I'm going to throw your butt in jail. Do you understand? There's no tolerance. Do not consume alcohol. Do not consume illegal drugs. Otherwise, you will go to jail.
And Judge, could you also discuss, and I know you know, and I know, just so that the client may be aware as well about things like mouthwash and things like that?
When we mean no alcohol, that means no alcohol of any kind, any source whatsoever. Anything in this life can create alcohol if there's any kind of sugar in it. A banana, an apple, mouthwash has it, just NyQuil. If you use anything that has alcohol in it, you will go to jail. After a while, things ferment. They turn into alcohol if they sit out long enough. You understand. Those machines are extremely finicky. So if I were you, I probably wouldn't blow into it after you consume whatever it is that you use, at least 30 minutes, you should give a window before you blow into that machine. If you blow within a couple minutes of eating or drinking something, you may very well cause a false positive. And everyone here tells me that they've consumed mouthwash. I've heard everything: a tequila lollipop, hair dye, mouthwash, everything. No means no. Do you understand? I'm not asking you to split the atom. I'm just asking you, don't consume alcohol. Don't use illegal drugs. Don't use any vehicle that's personal that doesn't have an interlock on it. If you do, likewise, into jail you go. I will pay for everything for you, so there's no excuse. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. Likewise, while you're on bond, you're not to be in possession of any weapons as well. So now we will have you meet, sign a reset. You'll get with Veronica for your bond conditions, and after that, you're free to go.
Thank you,
All right,
Your Honor.
please. Okay, hey.
Good morning, Your Honor.
What's up? What's up?
We have Christopher Constant to plead for time.
Okay, you ready?
I am.
Yeah, come on.
And I did
I
want
see it. I'm okay with it.
Okay, yeah, with the 29th.
Yeah.
Thank you, Judge.
Yeah. Let me do these two things and then I'll sign on. In 1 second.
Sure.
Mr. Cox, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. The agreements you have worked out is 15 days in jail with credit for the 2 days that you've done. Is that how you understand the agreement? I will allow you to report by 5/29 by 6 p.m. If you fail to show up, the entire range of punishment is available for us to put you in jail 180 days. You understand? Also, you have to show up on time. If you were someone who's perpetually late, don't be late because they're not going to take you. You show up at 6:01 and then we will have issues. You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. How do you plead to this offense? Guilty or not guilty? Are you guilty of this offense? Are you sure? Okay. Sure, I'm going to find you guilty. I'll follow the agreement, send you to it. Good luck to you.
Thank you, Your
Thanks.
Honor. Appreciate it. Good seeing you.
Good to you. Take care.
Come
Come on up, Mr. Bailey.
How are you doing?
Hey, man, what's up?
What's he giving today?
What's the last name? Alvarado.
He's in custody.
Okay.
Your, the offense in this case is March. I was appointed last month. Everything is in minus a writ.
It's only 74 days.
It is, Your Honor.
Did you want to do something?
I wanted to ask, yes, I would like the quickest trial that I can.
You want to get a trial date?
I would like that. I'm sorry, I'm still trying to cut up the name. Stuck through there for a second. Just set a trial that noted Alvarado Obando.
He wants to set up for trial. Are you ready? Is everything in?
Mine is checked. There's been 2 attempts to contact her, however, contact the plain witness. However, the plain witness has been contacted the DA's office because she has provided an affidavit on prosecution. I did not procure that. She did that on me. I'm not. I'd like a setting to evaluate the plain witness.
Can you make it a really short setting?
Absolutely, yeah, I can do
Okay.
that next week. That's fine.
Yeah, pick a day next week. Let him eval it without the CW. Let's go from there and then, yeah. And then at that point,
I do. All right, maybe see Judge.
thanks, Mr. Bailey. Give it a second. Okay, are you ready? Hi.
All right. Update on, Cruz Ortega.
Yeah, yeah.
Bond Foundation. I did file the rate motions to council and.
Sure, I'll sign it.
Also, I went upstairs and Judge Warren, gave her a $10,000 bond and withdraw
Okay.
And we have a bondsman here.
I can't let her do a walkthrough on a felony case. That's not my case. Sorry.
Okay.
I mean, if you go out there and post bond now, can she go pay the bond real quick to try to? You want to see, can you try to convince them to pick her up? Because on ours, I haven't done anything yet. I haven't revoked her bond on ours. So you could theoretically go get them, bring her upstairs, and then they'll let you go do the walkthrough. But it's a felony case. I can't let her go on a felony case. Like what you're asking me to do here, they need to do it. I can't do it on a felony case.
Well, no, he said he did. Like, he said that he was fine. He wasn't gonna have to do it, right? He put the $10,000 bond in and said that, what she was done here, or if you were releasing her, then.
I can't release her because it's a felony warrant. That's the problem. Right? If they go upstairs and if a bailiff comes down here, comes get her, takes her upstairs, then he could let her walk out because it's his court. It's a felony case. I can't let someone go on a felony warrant.
We need to address the, bond rights.
I can't. No, PC's not been found upstairs.
Okay.
I'll carry it. So she's going to post bond upstairs, right? So as soon as she posts bond, if they come get her, he could do PC upstairs, do everything, and then let her go do a walkthrough, right? Today.
Okay.
If not, they'll get her downstairs. They'll mag her probably tomorrow, and then we'll be back
We did PPC and PC went around.
On the felony case?
Yeah, he's not there. That's right.
Oh,
I'm confused.
okay. Well, I didn't know that.
Oh, okay.
Let me see. Give me 1 second. Let me try to get this thing working. I don't know. It's weird. It's not working.
Over my head right now.
Let's try it again. Yeah, internet's not working. Yeah, I'm gonna have to use my phone.
Yeah, this
Do you mind bringing her out? Here, I'm gonna let you do it on my phone because the only button's not working. Watch the Lucas. Okay.
So it's 2 classes for.
Yes.
Excuse me.
Hey, you can turn it down some.
Education, mitigation package.
All right, Ms. Cruz Ortega. So it's come to my attention that they have found probable cause to go forward with your case upstairs. I ordered you as a condition of your bond not to have any kind of this contact with the complaining witness in this case. Being that you picked up a felony and that's the same complaining witness, I'm going to revoke the bond on this case. I'm going to set it at 5,001. And let me tell you something, I will now issue another protective order. You are ordered not to have any contact with this person. If you do, I will deem you a public danger and I'm going to make your bond extremely high. I don't care what you got to do. I don't care if there's kids. I don't care if you have a pony with this person. You have contact with this person, I'm going to add. Do you understand? No contact means no contact of any kind. Okay, I guess that's it. We'll take her in now. If you can get someone to come down and get her, I'll allow you to do a walkthrough with us to take them out and then you do it on both. Okay, thanks. No, with you, just, yeah, no drugs, no alcohol, no weapons. Yeah, okay. Do you need the cause number, Veronica? You got it? Okay. Do you guys have the cause number?
Yes, I'm sorry.
Yeah, you got it? You got it? So 5,004.
So, but you know, you're asking for the reason, you're asking. Okay, so it's not somebody. Not reason to reach out. We have to look, okay, so we have 2 meetings.
Hey, did Homeboy fill out a financial affidavit?
You just decided not to hire himself.
Oh, he did? Oh,
So all
got it.
about to do is risk.
I just signed the conditions. Hi, Corey. You ready? What's up, Beth? Okay, sure. Anything particular you guys want to do?
Something to figure out. Yeah,
What are you thinking?
Figure out what I want to offer, Judge. Our complainant's got an attorney, they're asking for like straight probation. Mr. Ross asking for a dismissal. Is the case that originally was charged as possession of child porn or just distribution of child porn. It was dismissed.
This case?
In this case, there was a photo of a child with penis that was superimposed on their face. And it was like sent out as a text message. So it was dismissed as possession of child porn. It's not child porn, but I mean, it's still a serious offense. And I have a couple of different people asking me a couple of different things. This is the first time I'm on the case looking at it. So I just.
Why don't we take a week to think about
It
it?
won't take me long, but.
Yeah, are you okay with a week?
I'm out of town the next week, but the following Friday.
Yeah, but at that point, it's, probably close to 200 days. We need to figure it out. So,
It was the 2B for a little while, but, right.
just make sure she'll come at the next setting so we can figure it out. You know, if you want to set it, just be ready and then
Okay.
we'll go from there.
Sounds
Yeah,
good.
okay,
Appreciate it.
thanks.
I'll send you something.
But I was like.
You okay? What's up down there?
They don't have to approach on that.
Who is it? Hey, who is it? Stacy. What's up? It's 190 days on an interference.
Yes, Judge.
What's the word, Thunderbird?
There's a couple of offers, that state have made, Judge, and I'm talking to my client about maybe considering a trial. There's a couple of videos that they've been released since March, but I hadn't seen them. My little check mark was on there, so I got.
So pick a day next week, but that's it. You're at 190 days old. It's old. So next week, just be ready for clear trial.
Some of the judge.
Do you have any other old cases?
I think it might be Morales, Judge, but she's not here today. She is until her day.
Okay, I mean, you're at 160. The problem is I don't want to get up here at 180. Well, we want to do PTI now.
No, I'm pretty sure she's over there. I think
Are you sure?
because, no.
Well, then so on that one, we'll give you 2 weeks because you're getting up there. Just figure out where you want to go with it. If you want to do PTI, is she eligible? Or is she approved or does she need a mitigation package?
I do not believe we had a application in.
Sure, but I want to know, is that all they need or do they need a mitigation package?
12.153. No, there were not.
Okay, so you're probably approved. All she needs to do is fill out the application. If they grant it, then, we'll walk through. But other than that, in 2 weeks, if she just want to do whatever, just have her come and do it. Yeah. Okay, okay. Have fun. What's up? Yeah.
Judge, I have 3 cases for you. First one is Siobhan Taylor.
Okay, so you're at 142. So just a heads up.
Okay.
And I believe he's on.
Yeah, he just needs to come sign them and then that's it.
Okay.
Yeah.
I also have,
Tuesday,
Zertu.
30th?
And so I understand she turned herself in on the warrant today. I would ask your honor to consider giving her a PR bond. But I understand that there was a mix-up.
Mix-up?
Yes, so she was arrested back in January of last year on this charge in Odessa. She posted her Harris County bond while she was in jail, Loudoun County. And they did not tell her about the new court date here. So she didn't know that there was a court date exist. Additionally, Judge, she is 15 weeks pregnant.
She paid a cash bond last time. As soon as you pay a cash bond, they give you the actual reset date when they give you, and when you pay the cash bond. And then she makes another out-of-county bond 4 months later, and then she fails to appear again. Right? Is that what we have?
So I do see it. She is from the 13th.
Did you see the bail bond company over there?
Oh, can I?
They're here for her.
I see. Can I speak?
Come on
May I
up.
approach?
Yeah, of course.
Just made it. Number.
Yeah, sorry. 254, I'm sorry, I thought you had it.
No problem.
254-7697. Ms. Zertucci first posted a cash bond, looks like on January 17th. She signs it, which has the date on it. And then, so we issue a capias because no one, I guess, appears. And then she posts May 6th an out-of-county bond.
She posted on April 17th in Midland, Texas. And then they put a court date or the bond into the system for the 6th. And then.
Well, hold on.
Okay.
Let me see. You said she posts Midland, May 6th, or it's filed May 6th. And they put signed April 17th, 2026, court date.
We checked on 5/5 and there was nothing in there, sorry. And then the next day, that's when they put the actual court date, I'm guessing on the 6th. So we weren't able to let her know. She actually drove down here 8 hours today. So she could make sure. And I had spoke to this young lady, Brianna, and she just said to come in the court and I'll be able to approach you. And just explain. And she's been doing everything in our office, correct? Checking in, doing everything she needs to do.
So where does Ms. Zertucci live now? She lives in Odessa?
Just, I do understand that her husband's family isn't Houston, so if there is a stay in Houston condition, so people call.
No, I usually don't, but the problem is that now is multiple times, but okay. I'll reinstate the bond today with the understanding that I will not do it again. If she fails to appear again, next time I'm going to multiply it by who knows what. And it's just, I'm not going to reinstate it again.
Yes, sir.
You know, at some point we have to hold people accountable. You can't just keep, and now she'll get a physical, actual, right.
Correct.
Not only that, the case is now 4 months old. So we're already at the 120-day mark. So we usually, like they said, do you mind bringing it out, please? So let me just warm her out and then I'll tell her.
And Judge, there is a fast and distant offer on the case.
Okay. If she gets it done, then she doesn't have to appear, but that's on her, right? I mean, how many times have we had it where you have to beg people to do a dismissal and they still don't do it,
Thank you for considering.
Of course. This is not a revolving door. You don't get to post bond, take flight, post bond, take flight, post bond. At some point, we have to hold you accountable. This is not a revolving door. Imagine if we did that for everybody. I mean, it would be complete chaos here. So at some point, we have to hold your feet to the fire. This is now that time. If you ever take off on us again, I'm going to multiply the bond by who knows how much, and you will not get another PR bond. And I don't care if you turn yourself in. If Jesus brings you here, you're not going to get another one. Do you understand? So your lawyer has negotiated with you an offer where if you complete a course, they will dismiss this case against you. The case is now 120 days old. We set cases for trial at 180 days. So we'll give you 30 days, but at that time, you either need to be back here, be ready to set this case for trial, or have everything done. But at that point, that's it. You understand? Okay, so we are now, not only are we going to give you a physical reset form that's going to have your actual date on it, but we've given you a lawyer and you're going to have his phone number. So there's no excuse. Do you understand? Okay, good luck, man.
Thank you.
Thanks, guys. All right. Did you guys get the phone number on the card number? Yeah, okay. Let me just write this down, Adam, so I don't forget. Okay.
And Judge, I have an off-docket, matter for you. I have a question.
What's it costing?
It's 2595705.
On Gray.
Yeah.
Okay.
So on this case, there is a review condition. I'd ask the court to lift that for 1 day.
Why?
His hostess was having a birthday party in Dallas on the 28th. He doesn't understand, of course, that, I mean, I don't know if it was.
Does he have any devices now?
He has a scratch device, yes.
Okay, so, okay, but I don't want him out in the middle of the night. Like he's not out, he's not, come up, Mr. Gray.
I intend to plan to suspend the night in Dallas.
That's fine, but I want him indoors at a reasonable time. He's already had 2 different bond violations. I don't want him out. Nothing good happens at 2 in the morning when you're on bond for a DWI, especially when you have 2 different bond violations. I'm okay with you going over there, but I don't want you out at 2 in the morning. Nothing good happens for you who are on bond for DWI in college at 2 in the morning. There is no partying while you're on bond for this case. Do you understand? Partying with alcohol and illegal drugs. You're going to get tested as soon as you get back for illegal substances. Do not use. There are a lot of people that will tempt you because temptation is a bitch, especially when you're on bond. Do not use. I don't care how raging this party is. If you get dragged under, you're the one that's going to jail, not them. Do you understand? So, what's the curfew now?
It's 10 to 6.
Okay, what do you want? You want more time?
My sister's only 13, so I'm just going.
Oh, okay, well then, great. We'll keep the, yeah, I'm cool with you going, great. Just,
Yes, Judge, I'd ask that just on, I guess the, evening of the 28th to the morning of the 29th, I have that it be lifted during that period.
for all night? No.
Well, just because he'll be out of county, so.
Yeah, I get, no. If you go to Dallas, great. You can go to Dallas, just don't be out in the middle of the night. You're fine going to Dallas. You can go to Alaska, you can go to Abu Dhabi, I don't care. Just don't be out in the middle of the night.
I'll be back at 12 at the latest, probably.
For a 13-year-old's birthday party?
I mean, I don't know what we're doing, but like.
I mean, who the hell's hitting a piñata at 12 at night, man?
Nah.
I mean, I get it, you know, hitting a piñata at 13, but,
It's fine.
but
Dinner,
I mean,
something like that, but like at the latest.
fine. Just be smart. That's all we're asking you to do. Just if you see someone doing something wrong, don't get involved into it. It's not hard to comply. We're not asking much from you. Great. For this time, he can have it till midnight, baby steps, and then that's how we do. Trust is very easily broken and it's so very hard to get. Don't break it. You understand? Okay. All right, Dan. Got it. You got it, man. Is that Mr. Pollard over there?
Yes, Judge.
Where's Mr. Pollard been?
Check in. He just came and sat down, so nobody knew what he was here for.
Come up, Mr. Pollard. Why are you now getting here at 12:50, 12:45?
Well, I've been here since.
Says who? I don't believe you. Everybody's supposed to check in.
Oh, well, I didn't actually.
Court starts at 8:30 in the morning, not at 9:01, not at 10:35. You got to be here just like everyone else. You were charged with criminal trespass. You're facing up to 180 days in jail and or a $2,000 fine. We were going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Officer was dispatched to a disturbance at Specs Liquor Store. Complainant stated that defendant pulled up in front of the store and parked his vehicle in a handicapped spot, then attempted to enter the store. Complainant told defendant to remove his vehicle and park somewhere else because that spot is reserved for handicapped customers. Defendant ignored him and proceeded to go inside the store. Complainant told defendant if he does not move his vehicle, he is not allowed inside. Complainant told defendant he is trespassing and needs to leave. Defendant ignored him and entered the store. Witness, a security guard, also told defendant to leave the store, but defendant ignored him and refused to leave. Witness attempted to grab defendant to escort him out of the store, and defendant pushed him off with both hands. Witness attempted to detain defendant and ended up getting in a tussle with him.
Over a silly parking space that is reserved for handicap. Stop. I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to go back to any specs whatsoever for any reason. If you do, if you pick up a new case, I will revoke your bond, put you in jail. You will not get any more PR bonds. This is not a revolving door. Do you understand, Mr. Pollard?
Yes.
As a condition of your bond, you're ordered not to drive unless you have a valid Texas driver license and liability insurance in your name. Does he have a Texas driver's license? Please,
Yes, Your Honor, I'm running it right now.
please. No. Nothing you say at this point matters. I have found probable cause. And I'm telling you what the conditions of the case are. You either live to the conditions or you die by the conditions. You need a lawyer to represent you in this case, and we will give you time to go hire a lawyer. So we're going to reset your case.
His license is eligible, Your Honor.
So at this point, I'm going to have you sign a reset. After that, I'm going to have you take your seat in the jury box. We will have bond conditions created for you to sign. I'm going to protect my community at all costs, Mr. Pollard. That includes every parking space. You violate any of these conditions, it's just not going to go well for you. From now on, when we have court, please show up at 8:30 in the morning, check in. If you come late again, there's a very big possibility that I revoke your bond and put you in jail. You understand?
Yes, sir.
Okay, so I'm going to have you sign a reset. After that, we'll just have you take a seat while we get the bond conditions. Once you sign them, at that point, you'll be free to go.
And there you have it. A marathon session in a Texas courtroom that covered everything from reckless driving at 140 miles per hour to public indecency behind a daycare. The judge's message was consistent throughout. Bond conditions are not suggestions, and the revolving door stops when I say it stops. Mr. Brown learned that driving without a license or insurance while on felony bond will get you an affidavit and a threat of 180 days in jail. Mr. Martinez learned that a third DWI means 10 years in prison if he ever makes that mistake again. Mr. Nunez and Mr. Lane learned that a daycare parking lot is not the place for a romantic rendezvous. And Miss Ferguson learned that ignoring a PTI for 385 days means losing your chance at a clean record forever. The broader implication here is crucial. Judges have enormous discretion to set bonds, impose conditions, revoke probation, and send you to jail. And when you test their patience, whether it's by driving drunk, showing up late, or simply doing nothing, they will use every tool available to hold you accountable. If you found this case breakdown as entertaining and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next session.